Hello and welcome to the Street Crime UK YouTube channel. Please don't forget to like, share, comment and subscribe. This is a follow-up video from the one we made on Alex Belfield earlier. This is the judge's sentencing remarks and judgment on the Crown's application under the Section 5A of the Protection from Harassment Act of 1997. The Honourable Justice Dehaney said, "Mr Belfield, on the 5th of August 2022, following a 5-week trial here at Nottingham Crown Court, the jury convicted you on 4 counts. On count 5, you were convicted of stalking Mr Bernard Spedding, known professionally as Bernie Keith. I will refer to him by that name. By stalking Mr Keith, you caused him serious alarm or distress. On count 5, you were convicted of stalking Ben Hewiss, also causing him serious alarm or distress. On count 7, you were convicted of stalking Philip Dehaney. On count 8, you were convicted of stalking Jeremy Vine. Counts 5 and 6 are the more serious form of aggravated stalking because they cause your victims serious alarm or distress. Counts 7 and 8 reflect on the less serious form of stalking under the law. It now falls to me to sentence you for these offences and to deal with the Crown's related application for restraining orders against you in relation to Mr Keith, Mr Hewiss, Mr Dehaney and Mr Vine. Those orders seek to prevent further harassment of these people. I will refer these individuals collectively in my remarks as the complainants. At the end of my sentencing, I will also need to deal with a separate matter, which is the Crown's application for restraining orders against you in relation to the 4 complainants, where the jury acquitted you. Those were counts 1 to 4 concerning Rosina Breen, Helen Thomas, Liz Green and Stephanie Hurst. I will deliver a judgment on that application when I conclude my sentencing, and it will be available as an amendment to the sentencing remark that I am now delivering. The applications for the restraining orders are not opposed by you, but I need to give my reasons for making them. My attention has been helpfully drawn by the Council of the Intermediary Offences Guideline. I also have considered the general guideline of custodial sentences and the totality guideline, as well as the material provisions of the Sentencing Act of 2020. Given that they were separate crimes against separate victims, which I considered need to be each marked with distinct sentences, I propose to pass sentences which will be served consecutively. I am aware that certain of the facts overlap, but consider nevertheless that this is a case for consecutive sentences given the particular forms your harassment of the different victims took. Your offences are so serious that only a custodial sentence can be justified, but because I am sentencing you for more than one offence, I must assure that, standing back, the total overall sentence reflects all the offending behaviour in just and a proportionate manner. That is the principle of totality, to which I will make reference to in my remarks, and which you have heard counsel discussing with me. I would apply by that principle by adjusting each individual consecutive sentence. I have received very helpful oral and written submissions from Mr Guinness KC and Mr Rowcliffe, and from Mr Aubrey KC for you. Mr Aubrey KC presented your mitigation in measured and realistic manner, recognising that the custodial threshold has been crossed. I am grateful to him and Mr McGuinness KC and Mr Rowcliffe for the substantial assistance they provided me throughout the trial. I have had regard to the moving victim personal statements which have been submitted to the court. I emphasise, however, that the issue of the appropriate sentences is for me and not for your victims to decide, applying the relevant guidelines and the law. A very helpful and detailed pre-sentence report is before me. The report shows that you have fully acknowledged the distress you have caused your victims, but highlights that you still appear to focus on the impact of events on you and feel in certain respects that you have been unjustly treated. I have read several character references provided by you and accept that they speak in positive terms about you and commend your work in the community. Mr Aubrey KC has also reminded me of your successful career and online following, and underlined your particular style and broadcasting persona. It is also clear that you come from a close family and you have acted with real kindness in assisting those facing substantial challenges in their lives, particularly during the pandemic. It was also submitted that custody would have a profound effect on you and those dependent upon you, including 9 employees. Where I state findings on the fact of my sentencing remarks, I am satisfied of those facts on the evidence called before the jury to a standard which makes me sure of them. A different civil matter applies when I deal with the Crown's applications for restraining orders. It will begin with some of the common features of conduct on the basis of which you were convicted by the jury. I will then turn to the specific victims. The stalking you committed was not the conventional type which is popularised in the press. You did not meet or physically approach or watch any of your victims as a traditional stalker might have done. Your methods were, however, just as effective as a way of intimidating your victims, and were in many ways much harder to deal with. Your stalking consisted of repeated email communications, social media content on Twitter, and creation and publication of YouTube videos on your channel, The Voice of Reason, in which you commented in highly negative and often abusive terms about the complainants. As you described in some of your videos, your aim was to haunt the victims. They gave graphic evidence that they believed you would be true to your word and would never go away. It was only the imposition of the bail conditions restraining your actions which had given them peace in the period to the trial. A number of witnesses said that you had weaponized the internet. I find that to be a wholly apt description of your conduct. The emails were very widely distributed and not simply sent to the direct victims. When the victims sought to block your emails, the common device you used was to use different emails to get through to them. That tactic was used by you on many occasions. In some instances, you used the technique of identifying the personal home address of the individuals in your communications, which understandably caused them to fear for their safety. Their feelings of the effect of being followed or monitored were justified. The YouTube videos and tweets reached your very substantial audience. The effect of these communications was to encourage the readers and viewers to form a highly negative view of the complainants, often based on wholly false allegations by you. Those readers and viewers then joined the abuse of the complainants in a way which is now a sadly familiar feature of social media interaction. Online stalkers like you have the ability to recruit an army of followers whose conduct massively expands the affecting of your stalking. That is why I say your stalking is, in many respects, more serious than a conventional stalker. I accept that in certain limited respects, you were acting as a form of media commentator in stating views on matter of public interest when you made some of your communications. However, even accepting the latitude our law gives to those exercising free speech rights, on the jury's verdicts, you exceeded the generous margins. You made communications which had serious impacts on private lives of the complainants, with distressing effects on their mental and physical health. I find that the motivating factor in your communications about these complainants was not the exercise of journalistic freedom to comment on matters of public interest, but personal grudges and response to real or apparent slights. I am not imposing sentences on you because you made comments about the BBC or matters of public interest. Your sentences reflect the repeated and personal harassment of victims and not your views on any issue or public interest. You are entitled to hold and express views, but you are not entitled to destroy the personal lives of your victims through online harassment. I now turn to the specific counts. I have taken into account all of the oral and written evidence at trial, but in the interest of brevity, I will only summarise the nature of your conduct towards each victim at a high level in order to explain my sentences and the application of the guidelines. The first is count 4 on Bernard Spedding, also known as Bernie Keefe. Turning first to count 4 concerning Bernie Keefe, he is a highly respected and established presenter of many years standing at the BBC Radio Northampton. Your harassment of him took place over a substantial period of time. These were the 9 years between 2011 and 2020. It was only at the very end of this period that the harassment overlapped to some extent with that other of the complainants. Having once been a friend and an acquaintance, your campaign and harassment against Mr. Keefe first took the form of many emails which sought to criticise any aspect of his shows, and then moved into highly offensive material. He did his best to ignore your communications. He asked you in polite and restrained terms to stop. You did not. There have been many communications, and not all were produced in court. They appeared to have become less frequent around 2018, but your communications escalated substantially from 1st of October 2019, when you suspected that Mr. Keefe had communicated by email with a person he did not know, Mr. Hewiss, to warn him of your past behaviour and to inform him of what he believed you had done to other BBC employees. Mr. Hewiss then published part of an email from Mr. Keefe Keith in a tweet. You then bombarded Mr. Keith with Facebook messages, emails, and highly abusive YouTube videos about him, including false allegations that he had mental health issues. Even when he instructed lawyers for you to communicate with, and they requested you not to contact Mr. Keith, you continued to send repeated abusive communications directly to Mr. Keith. He had no escape from you. There is no purpose in communicating directly other than continuing your campaign of harassment. Mr. Keith gave the jury graphic and distressing evidence of how close he came to hanging himself. He was seconds away from taking his life as a result of your conduct. You made this highly successful and confident radio presenter lose all joy in life and turned him into a shell. Mr. Keith also felt at serial physical risk of attack, although at no point did you commit any physical acts against him. Mr. Keith gave evidence which I accept of heightened awareness of individuals, additional security measures, and said he gave his fellow villagers copies of your photograph. He was terrified of you. I find that count 5 falls within category A1 of the relevant stalking guideline. That is the most serious category. As a culpability, the history I have summarised demonstrates that your actions were conducted over a sustained period, and I find were intended to maximise Mr. Keith's distress. Your actions were of an extreme nature and pushed this matter clearly into the top of the culpability range. As to harm, I have identified very significant distress was caused to Mr. Keith. I need to identify the starting point for your sentence. Your stalking of Mr. Keith, as charged on the indictment before the 3rd of April 2017, the date when the maximum penalty was increased from 5 to 10 years. The guideline reflects this higher penalty. It is common ground that the maximum penalty for this count is 5 years imprisonment. If your offending had been post the 3rd of April 2017, the starting point under which the guideline for this form of stalking would have been 5 years. Both the Crown and your counsel submitted, and I accept, that I should move down from the starting point to take into account the lower earlier statutory maximum of 5 years imprisonment. I will take a starting point of 2 years and 6 months. I then need to consider the aggravating and mitigating factors. There are the following 2 matters which I have not already taken into account of my categorization. They justify upward movement from the starting point. First, the fact that your postings publicly about Mr. Keith resulted in the followers of your social media profiles abusing him over a lengthy period. In some cases, this is extended to death threats. Second, the false and scandalous accusation that Mr. Keith had regularly had sex in public on gay beaches with strangers for 2 decades, coupled with the threat to include the allegation in the story, which you would then sell for publication. The mitigation is lack of previous convictions and previous good character. There has also been some remorse expressed. As recorded in the pre-sentence report, I make allowance for these matters, and I have also in regard to the principle of totality in making the adjustment to my sentence. Having regarded all these matters, I impose a sentence of 2 years 6 months in respect to count 5 concerning Mr. Keith. The next was count 6, Ben Hewiss. As to count 6 concerning Mr. Hewiss, he is a videographer who works in theatre and the wedding industry. You did not know him and have in fact never met him. His problems began when he went online in late 2019 to support those in the theatre who he believed were being unfairly attacked by you on Twitter. Your stalking of him took place between the end of 2019 and went into mid-2020 when the police became involved. Your attacks on Mr. Hewiss took the form of both personal emails as well as highly distressing YouTube videos. You felt that Mr. Hewiss had libelled you by a post on Twitter which included part of a private email Mr. Keith had sent Mr. Hewiss on the 1st of October 2019. I've already referred to that email, and I am sure Mr. Hewiss will regret for the rest of his life that he included that email in his tweet. That is because it led you to direct a flood of abuse towards him. Despite a rapid apology and retraction from him, you claimed in multiple communications to have hired and paid lawyers to sue Mr. Hewiss. Those statements were false. This is the intermediary behaviour towards a man who felt his family and home were at risk. I find you had no intention of taking legal action, but decided to use the online threats as a way to obtain details of who had supplied Mr. Hewiss with the information about you, which he published in his tweet. Mr. Hewiss then gave compelling evidence as to the distress he suffered and wished to keep his pregnant wife out of the dispute. The statutory minimum for this offence is 10 years. I find that this stalking was category B1 within the guidelines. As to culpability, I find your actions were intended to maximise distress to Mr. Hewiss and took place over a substantial period, albeit a period shorter. As to the harm, it is clear that serious distress was caused to Mr. Hewiss, and he has had to seek professional help as a result from your offending. The category B1 starting point is 2 years and 6 months imprisonment, with a range of 1 to 4 years. As to the aggravating factors justifying upward adjustment, there are 4 factors increasing the seriousness, as to which I have not already taken into account in my categorization. First, you involve Mr. Hewiss's family by using in your videos pictures of his wife and young child. You attached an image of a fetal scam to an email to attempt to contact his wife. Secondly, you contacted Mr. Hewiss's clients intending to undermine his business. Thirdly, you encouraged his followers to contact him, and your posting publicly about Mr. Hewiss resulted in your followers of the social media profiles abusing Mr. Hewiss. Fourthly, Google searches continue to reference articles about Mr. Hewiss which remain available on your websites, thereby not only perpetuating the distress but also the financial effects on Mr. Hewiss. These matters justify upward movement from the starting point. As to the downward adjustment, the mitigation is lack of previous convictions and good character and remorse in the form as I have stated. These matters justify some limited downward movement, and I also need to adjust the sentence to take into account the principle of totality. Having regard to all these matters, in respect to count 5 concerning Mr. Hewiss, I impose a sentence of 2 years 6 months imprisonment to run consecutively with the sentence on count 5. Count 7 was on Philip Dehaney. As to count 7 concerning Mr. Dehaney, the jury acquitted you of the more serious form of stalking but found you guilty of the lesser alternative of the basic stalking offence. I must respect the jury's acquittal on the more serious charge, and it is of relevance when I consider the levels of harm caused. Like Mr. Hewiss, Mr. Dehaney was subject to a vicious and continued campaign of abuse, principally by the way of YouTube videos. He was a theatre critic and a blogger who did not wish to be tagged by you in what he regarded as an offensive tweet about those in the industry. He had never met you. He asked that you cease. Your online attacks and emails began in the early new year of 2020. You wrongly believed that he had repeated the contents of Mr. Hewiss's tweet. You again made false representations as to the intended legal action. This victim started a blog in which he provided a day-to-day account of your abusive conduct. That inflamed you further. When Mr. Dehaney became uncontactable and refused to engage with you, you went as far as calling his mother during lockdown at the family home. We heard a recording of that call. She is clearly a robust and impressive person. Everyone needs a mum like her. Mr. Dehaney's mother repeatedly and fairly asked you again and again what had her son done that was wrong, and you failed to provide any answer. The call was, in my judgment, part of the harassment of her son, who stood by while she took the call. It was an outrageous and cruel act to call her and to make a recording. Not only did you record the conversation, you then made false and misleading comments about what she had said about her son, seeking to demean him in a public forum. Getting his parents involved caused serious and continuing fractures in Mr. Dehaney's relationship with them, and in particular with his father. You also sought to humiliate Mr. Dehaney about his mental health in your postings and videos. Further, you sought to, in effect, blackmail him with revealing details of a long-spent conviction. The content of the YouTube videos you made about him at a time when he was clearly vulnerable and shielding with his parents during the first lockdown, and it was shocking. The statutory maximum for this offence is 6 months imprisonment. I have to, however, consider the guideline. I find that this offence falls within the category A1 of the relevant stalking guideline. That is the highest category. As to the culpability, your actions were planned, repetitive, and intended to cause Mr. Dehaney distress and included hostility based on his sexual orientation. I do not consider the fact that because you are a member of the LGBTQ community, that means you cannot have acted with hostility based on Mr. Dehaney's sexual orientation. As to harm, regarding the jury's verdicts, including the acquittal, I find harm and distress, including psychological harm, were caused to Mr. Dehaney. Mr. Dehaney has been unable to continue his blogging enterprise as a result of your actions. This was a significant change in lifestyle. The category A1 starting point is 12 weeks custody, with a range of high-level community order to 26 weeks. As to the aggravating factors increasing the seriousness and justifying upward movement, there is one matter which I have not already taken into account. It is the fact that you posted publicly about him and that resulted reported your followers in the social media profiles abusing Mr. Dehaney. That magnified the effect of your abuse. These matters pushed the offence into the category range. As to the downward adjustment, the mitigation is lack of previous conviction, good character, and some remorse in the form that I have stated. I also have to take into regard the principle of totality and have adjusted my sentence. I oppose the sentence of 13 weeks for count 7 to run consecutively with the sentence of count 6. Count 8 was for Jeremy Vine. I turn to count 8 concerning Mr. Vine, who is a well-known radio and TV presenter. The jury again acquitted you of the more serious form of stalking, but found you guilty of the lesser alternative of basic stalking. Until trial, you had not met Mr. Vine. Your actions against Mr. Vine consisted of highly abusive and wholly false allegations, which were given mass Twitter and video exposure. These allegations to the effect that Mr. Vine had somehow stolen £1,000 of BBC licence payers' funds to use for what you called a pisser, or a party following a memorial service of a dear friend of Mr. Vine, Mr. John Myers. Mr. Myers was a prominent personality in the radio industry, and the BBC made a modest contribution to his memorial fund. Mr. Vine did not know about this at the material time, and the BBC contribution had absolutely nothing to do with him. Mr. Vine did not steal anything, nor did the BBC pay for the so-called piss-up. The allegations you made against Mr. Vine were wholly false. You boasted online about the fact that in excess of 400,000 people had viewed your video about Mr. Vine containing these false allegations. Your assertions into the video and tweets that your allegation was supported by the BBC answers to freedom of information requests was also wholly false. They provided no support, as was revealed at trial. You were not a whistleblower in any sense, but developed a fixation with pursuing Mr. Vine with a campaign of abuse. The effect of your conduct on Mr. Vine's family and daughters was significant. Although you at no stage committed any physical acts, Mr. Vine considered himself and his family to be at risk from you and your followers. He had to ask his family to watch out for you and take care in and around their home address. You published his home address to a mass audience. The statutory maximum for this offence against Mr. Vine is 6 months imprisonment, but I have to again return to the guidelines. I find that this stalking of Mr. Vine falls in the category A1 of stalking guidelines, the highest category. As to culpability, your false allegations were given to a wide publicity over the 2 months and were intended to maximise Mr. Vine's distress. As to harm, I recognise the need to give weight to the jury's verdicts, including the acquittal. I find that harm and distress, including psychological harm, was caused to Mr. Vine. He also had to make precautionary lifestyle changes for him and his family. The category A1 starting point is 12 weeks custody, with a range of a high level of community order to 26 weeks custody. As to the aggravating factors, which I have not already taken into account into categorisation, there are 2 matters. First, you actively encouraged others to contact Mr. Vine during his broadcasts to pursue the baseless allegation of theft of public money. Secondly, you encouraged others to provide private information about Mr. Vine's family and friends. Your false allegations against Mr. Vine led to a torrent of abuse being suffered online by Mr. Vine. That went to many thousands of abusive tweets received by him and personal threats. I consider that these aggravating matters take this offence up the category range. As to the downward adjustment of the mitigation, it is lack of previous convictions and good character and remorse in the form that I have stated. I also have to regard the principle of totality and adjust to the sentence. As for count 8 concerning Mr. Vine, I imposed a sentence of 13 weeks imprisonment to run consecutively with the sentence on count 7. I will now summarise my sentences. For count 5 concerning Mr. Keith, 2 years 6 months imprisonment. For count 6 concerning Mr. Hewiss, 2 years 6 months imprisonment to be served consecutively with count 5. For count 7 concerning Mr. Dehaney, 13 weeks imprisonment to be served consecutively for count 6. For count 8 concerning Mr. Vine, 13 weeks imprisonment to be served consecutively with count 7. This amounts to the total of 5 years and 26 weeks imprisonment. This is the shortest sentence commensurate with the seriousness of your offence and application of the principle of totality. You will serve up to 1/2 of this sentence in custody. You will serve the remainder of it on licence. You must keep to the terms of your licence and commit no further offences, or you will be liable to be recalled and you may have to serve the rest of your sentence in custody. I now turn to the issue of restraining orders, into the cases where you were convicted of stalking restraining these 4 complainants. You do not oppose these orders, but I need to give my reasons for making them independently of your non-opposition. Restraining orders under Section 360 of the Sentencing Act of 2020. Based on the jury's verdicts in relation to each of these complainants, and my assessment that absent a restraint, you will repeat the stalking and harassment, I am satisfied that restraining orders on an indefinite basis are necessary. Your past conduct and qualified expression of remorse establish that the court's intervention is necessary to protect these complainants. The terms of the draft orders before me are appropriately tailored to ensure that they only interfere with your freedom of speech rights to a limited and proportionate level. I accordingly make orders in the terms of the orders before me restraining you under Section 360 of the Sentencing Act of 2020. As regards each of Bernard Spedding, Ben Hewiss, Philip Dehaney and Jeremy Vine, you are, until further ordered, prohibited from contacting or attempting to contact them by any means, whether direct or indirect. You must not publish through any form of publication or electronic communication, any statement or any other material relating to or purporting to relating to them. You must not monitor the use by them of the internet, email or any other form of electronic communications. Any breach of those orders is a serious criminal offence with substantial criminal penalties which may include imprisonment of up to 5 years. You will be given a written record of the terms of your orders. If for any reason the orders are no longer necessary and appropriate, then either you or the complainants may apply to the court for them to be amended or removed. But until that time, which may never come, they will remain in force and must be complied with to the letter. The prosecution costs. The costs incurred by the Crown in respect to these proceedings are £27,990, and it makes for application for such costs. I am satisfied that you should be able to pay a part of these costs pursuant to Section 18(1) of the Prosecution Acts of 1985. I have taken into account the point you made on behalf of your acquittals and convictions on the lesser counts and the other penalties I have imposed. I consider a fair and proportionate amount is £10,000. Based on the ownership of a house, albeit a mortgage, and the income I infer you have received from your YouTube channel, and in the absence of other counter evidence, I am satisfied that you have the means to meet the cost of £10,000. Indeed, it has not been submitted that you do not have the means to pay them. The surcharge will apply. Finally, I turn to my judgment on the Crown's application for restraining orders in relation to those complainants where the jury acquitted you. Again, you do not oppose that application, but I need to be satisfied that it is appropriate for me to make these orders and to give reasons for my decision. The judgment of the Crown's application under Section 5A of the PHA 1997 in relation to the complainants in respects of counts 1 to 4 where Mr. Belfield was acquitted. The Crown applies for restraining orders against him under Section 5A of the Protection from Harassment Act of 1997. These complainants were Rosina Breen, Helen Thomas, Liz Green and Stephanie Hurst. Each of these persons gave oral evidence at trial. Section 5A of the 1997 Act empowers a court to make restraining orders against a defendant following his acquittal if the court concludes it is necessary to do so to protect a person from harassment. Nothing in this judgment seeks to cast any doubt on Mr. Belfield's acquittal. I am required to consider a separate question under the statute, which is the need for any future protection, even in cases where there has been an acquittal. That will require me to consider the evidence before the jury, but nothing I say seeks to question their verdicts. I am applying for the civil standard of proof in identifying the facts, unlike the jury when determining the criminal charges. The court may make orders which are either time limited or indefinite, but subject to the court's powers under the Section 5A 2B. At trial, counts 1 to 4 were grouped together because they related in part, at least, to the time of Mr. Belfield spent at BBC Radio Leeds and actions Mr. Belfield took in relation to BBC employees thereafter. There were many common features of Mr. Belfield's conduct in relation to these complainants, and I will, in the interest of brevity, summarise my findings by reference to the common facts which emerged from the evidence. I will, however, also need to make reference in brief to terms of the evidence concerning particular complainants. In coming to my decision, I have taken into the account the oral and written evidence presented by the jury. I also take into the account that the nature of the future restraints which the Crown seek to infer on Mr. Belfield's Article 10 ECHR rights is because they essentially seek to restrain speech and communications. Accordingly, I approach matters on the basis that the need for such future restraints must be convincingly established and the measures must be satisfied on a strict proportionality test. The court must balance the complainant's rights to a private life under Article 8 of the ECHR against Mr. Belfield's Article 10 rights. Based on the oral and written evidence before me, I am satisfied that the orders are necessary and justified. Each of the complainants required protection from Mr. Belfield. I will explain my reasons. The starting point is my findings in relation to past events. I note that the oral evidence of each of these witnesses was essentially uncontradicted by counter-oral evidence. I also find them to be wholly honest, impressive and straightforward witnesses who have achieved substantial success in their fields. They were profoundly damaged by Mr. Belfield's actions and they have had to seek for assistance from medical professionals. Each of them suffered serious mental health problems arising from Mr. Belfield's conduct. The longest periods of abuse were suffered by Miss Breen, Miss Thomas and Miss Green. I find that in relation to Miss Breen and Miss Thomas, abusive emails running into the thousands were sent over a 10-year period. In relation to Miss Green, there were hundreds of emails. In relation to Miss Hurst, there were not as many emails, but there were highly offensive and transphobic social media posts and videos. I accept that the evidence of these complainants, that although a relatively small number of emails were produced in court, the policy they had been directed to follow was to delete any email which Mr. Belfield sent. These complainants did not respond to his emails. They did not encourage him in any way. In short, they did nothing in response to the barrage of communications. Yet he continued to target and harass them over long periods of time. I have not overlooked the fact that in many communications, Mr. Belfield was, aside from abuse, also making points on matters of public interest, such as the BBC's use of resources and listening figures, as well as concerns about content. However, in his communications concerning these complaints, he went far beyond that. His communications were often made to mass email audiences within the BBC, many of whom had nothing to do with the complainant. On occasions, he made highly offensive and personal comments about their physical appearances, including sexualized comments about them. The emails were often blind copied to them. I accept the evidence that Mr. Belfield effectively followed these women's online harassment through their careers. Most distressing was the fact that many years after Mr. Belfield had ceased to have anything to do with them professionally, he would email the very senior personnel in the BBC with a wholly false allegation that Miss Breen, Miss Thomas and Miss Green had bullied him. There was no escape for these complainants from Mr. Belfield until Nottinghamshire Police became involved in late 2020 and bail conditions prohibited him contacting or references to these peoples were imposed. I find that these complaints were targeted by Mr. Belfield because he held a personal grudge against them. As regards to Miss Breen and Miss Thomas, his former managers he felt had mistreated him during a brief period working at the BBC Radio Leeds in 2010 and 2011. Mr. Belfield also has a belief that women, as part of what he is repeatedly called a tick-box culture, were being promoted and given prominence within the BBC when he, as a person in his own view of real talent, was not being employed. I express no view as to this, save to say that such a holding of such a belief does not provide a charter of harassment of over 10 years. As to Miss Green, he felt that she had acted inappropriately towards him at the time when he was a radio presenter at the station. She had continued to work at BBC Radio Leeds when Mr. Belfield's contract had not been continued. As regards to Stephanie Hurst, Mr. Belfield felt that a personal insult was made when she declined to interview him following her gender transition. That turned into a campaign of transphobic behaviour which at every turn led him to isolate her transgender status and to ridicule her in his comments and videos. I do not accept Mr. Belfield's characterisation of his comments in relation to Miss Hurst as simply parody or comment of a comedic nature. They are more accurately described as a transphobic and hateful comment. comments. I find they were motivated in part at least by feelings of jealousy as to her success when his own career within the BBC was dwindling. It is striking that Mr. Belfield found it near impossible to make any communications concerning Miss Hearst without including highly offensive emojis about her transition. In each of these cases, it was essentially a personal campaign of revenge which motivated him as opposed to some form of journalistic exercise of holding people within the BBC to account. Applying the civil standard, I find that Mr. Belfield carried out a historic course of conduct against each complainant which amounted to statutory harassment causing distress and alarm, and that he ought to have known his actions amounted to harassment. I find that, based on the nature and extent of the conduct, on his police interviews and the nature of his defence in trial, that there is a very substantial risk that, absent the court's restraint, he is likely to continue such behaviour. In my judgment, Mr. Belfield's approach at trial did not indicate any appreciation of the extent to which he had damaged the mental health of those four women. An order which is indefinite in time is justified. I cannot, on the evidence before me, find that Mr. Belfield is likely in any particular period in the future to have an appreciation of the inappropriateness of his past actions. The complainant's right to a private life outweigh any freedom of speech right which Mr. Belfield may claim to exercise. The terms of the Crown's draft orders, as discussed in court, are, in my judgment, sufficiently tailored to go no further than protecting the complainant's Article 8 rights to a private life. They are proportionate and strike appropriate balance. They do not impose any restraint on the legitimate exercise of Article 10 of the ECHR rights. I will make indefinite restraining orders against Mr. Belfield in favour of Rosina Breen, Helen Thomas, Liz Green, and Stephanie Hearst under the Section 5A of the Protection from Harassment Act of 1997. As regards to each of these persons, Mr. Belfield is, until further ordered, prohibited from contacting or attempting to contact them by any means, whether direct or indirect. He must not publish through any forms of publication or electronic communication any statement or any other material relating to or purporting to relate to them. He must not monitor the use by any of them on the internet, email, or through any other form of electronic communication. Any breach of those orders is a serious criminal offence, with substantial criminal penalties, which may include imprisonment of up to 5 years. Mr. Belfield will be given a written record of terms of the order. If for any reason the orders are no longer necessary and appropriate, then either Mr. Belfield or the complainants may apply for the court to have them amended or removed. But until that time, which may never come, they will remain in force and must be complied with to the letter. Finally, I record that I consider each of these women acted with substantial courage and real fortitude in coming to the court to give evidence in a public forum about matters which had a very substantial negative mental health impacts upon them over several years. The court's orders today are intended to provide them with some protection, with criminal penalties for breach against any repetition in the future of any such conduct. Thank you for joining us today. What are your opinions on the judge's sentencing remarks? Do you agree with the verdict and the sentence that was given? Please let us know what you think in the comments below. Thank you for joining us today. If you enjoyed this content, please don't forget to like and share, and if you're new to the channel and want to see more Street Crime UK content, hit subscribe and press that bell so you can join us on the next video. Thank you for joining us, and until next time, stay safe.